In this short video, I'm going to talk about Section 230 of the Communications Decency Act. And let me start by putting that in perspective. You know, throughout history, we've seen a lot of advances in speech technology. Gutenberg's invention of the printing press was the first major breakthrough, and it certainly changed the world in many important respects, it led to changes in government, it led to the Protestant Reformation, and it led to a lot of advances in science and technology. Subsequently, we saw the development of technologies like radio, television, satellite, cable. All of those technologies helped dramatically advance the ability of people to communicate with each other. But the difficulty was that all of the technologies came with what I refer to as gatekeepers. In other words, people who can control access to those technologies. With Gutenberg, his printing press was expensive. It required lead type, and it was expensive to purchase lead type. So not everybody could own or operate a printing press. Over the centuries, what happened was they were primarily operated by book publishers or by newspapers. But what that meant was that ordinary people, if they wanted to publish, had to go through those book publishers or newspapers. And the owners and controllers of those technologies were the effective gatekeepers for that. Same thing was true for radio, television, satellite, cable. All of them were expensive. All of them had essentially ownership by wealthy or prominent individuals or corporations. The internet was the first major breakthrough in terms of technology that didn't really come with gatekeepers, in the sense that people could communicate widely with each other. And we saw the impact of that during the Arab Spring as protesters used social media accounts to convey information, to coordinate protest, and to challenge governments. And we saw that with the collapse of the government in Tunisia, in Egypt, and in other countries. We've also seen that the internet has had a major impact on politics and communication in the United States. And much of this has occurred because of the absence of gatekeepers. But I'm concerned today because of the importance and power of social media platforms. And I'm particularly concerned because Section 230 of the Communications Decency Act provides those platforms with two major advantages that are not available to other people. One is that it protects them against civil liability. Now, that probably makes sense. The idea is if you're going to have a social media platform and it's going to be open to anybody to post things on, it's not inconceivable that somebody's going to post something that is defamatory or illegal or presents other problems. And Section 230, correctly, I think, provides social media companies with protection against civil liability for things that others post on their websites. The idea is that the social media platforms are not editors, they're not publishers, and they shouldn't be responsible for what other people publish. My concern with Section 230 is that it also authorizes social media platforms to censor material. And it contains what's called a Good Samaritan defense. And basically what it provides is that they have the authority to censor obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable material. Now, under U.S. law, some of these things can be prohibited. For example, obscene material is considered to be unprotected under the Constitution, and therefore government would have the right to prohibit it, and therefore it doesn't really create a problem that we allow social media companies to prohibit it. But some of this language in Section 230 is clearly overbroad and allows broad authority to censor material. For example, objectionable material, I don't know what that means. Normally, when we talk about restrictions on freedom of expression, we say that you can't be unduly vague or overbroad in your restrictions on speech. A term like objectionable clearly is vague. Whose objection? I mean, what type of objection? We don't really know what it means, and it's probably overbroad as well. So under the U.S. free speech tradition, if the government tried to impose these types of restrictions, I don't think there's any question they would be considered to be unconstitutional. You know, the American free speech tradition includes a number of different ideas. One is that, in general, content-based restrictions on speech are considered to be presumptively unconstitutional and therefore subject to what we call strict scrutiny. And by strict scrutiny, what I mean is you have to show that there is a compelling or overriding governmental interest in limiting the speech. And secondarily, you have to show that the restriction imposed is the least restrictive means possible for accomplishing that objective. Plus, we're generally going to require that these speech restrictions be not vague and not overbroad. And I think this law suffers from both of those problems. And the other thing we have from the American free speech tradition is a presumption against the validity of prior restraints, like injunctions or other types of restrictions. In general, in the U.S., we don't even allow government to ban speech on the theory, if it happens to be false. There are some instances where you can ban false speech, perjury, false statements to government officials. Those sorts of things can be banned. Defamation, well, yes, in theory, you can have liability for defamation, but the constitutional requirements make it extremely difficult to impose liability in those situations. My concern with Section 230 is that it has allowed governments to ban individuals. In other words, to completely ban an individual from speaking on that particular website. We've seen that with Facebook, has banned Donald Trump, and actually has banned him through 2023. It banned Senator Rand Paul from speaking on his website. But those are hardly isolated examples. Yeah. A whole variety of individuals and groups have been banned from appearing on social media platforms, including Alex Jones, Louis Farrakhan, Milo Yiannopoulos, the Daily Stormer, the Taliban, InfoWars. Moreover, social media platforms have banned ideas and sometimes on the basis that they constitute disinformation, but has banned people from articulating certain ideas. Now, it'd be one thing if Facebook were infallible in terms of what constitutes disinformation. But, I mean, part of the reason we don't allow government to ban disinformation is we don't find typically the government is infallible. And we've found that Facebook is not infallible either. For example, for a while, Facebook was banning certain claims regarding the origin of COVID-19. And then it later decided, whoops, we made a mistake. And they allowed that information to go up. But there was a long period where it was banned. When we talk about governmental control of speech, normally we would say government doesn't have the power to determine what the truth is and to impose liability on people who espouse things that the government deems not to be the truth, or that it cannot ban those ideas. But in the case of social media platforms, we give them extremely broad authority. Don't get me wrong. I'm not arguing that there isn't disinformation on social media platforms. But the question is, what's the remedy? Normally, we don't allow censorship. We don't allow the government, for example, to decide what's true and what's false and to ban false information. And I'm not sure we should be allowing social media platforms to do that. The worry is that they will abuse their power by discriminating against views that they don't like or discriminating against disfavored views in society, and that they will prejudice the debate in terms of one position or the other. And so, obviously, this is a short presentation. I just wanted to raise the issues related to Section 230 and to essentially say, I think we need a reconsideration of where we are. I think there are several possible solutions. One is to simply remove the Good Samaritan defense and simply say that they don't have the right to censor material on their websites. That approach probably makes some sense because we give them exemptions from liability because of the idea that they're not editing or publishing. Well, under the Good Samaritan defense, they are editing and publishing. So it seems to me you should have it one way or the other. Either you should be allowed to censor and publish, or you shouldn't. Another idea is to treat them as what we call common carriers. Common carriers are open to the public. They have to treat everybody with equality, and you can't discriminate against content or viewpoint. That would probably be fine, I think. And there are certainly allegations that Facebook and the other social media platforms have been discriminating based on content and viewpoint. And there are other ideas. I mean, some argue that the First Amendment should be treated as applying to Facebook. Normally, private companies are not subject to the First Amendment. It's only a restriction on government. But if we applied the First Amendment to them, then we could argue that they're subject to the same rules that the federal government would be subject to, or the state governments. All of these are interesting ideas. The constitutional argument of applying the First Amendment to social media platforms is not completely far-fetched, because if you think about it, government has not only exempted them from civil liability, but specifically authorized the social media platforms to censor. And if you're going to go that far, then one can argue that essentially government is becoming complicit in what's happening, and therefore should have limited authority to censor those things. Well, we can talk about this more later. I'm going to be making a presentation in December about social media platforms, but talking about more particularly robotic speech. And I suppose in the question and answer session, we can talk about this at that time. All right, thank you.